Any establishment as defined by any state law is covered by the Maternity Benefit Act. This is also applicable to contract employees. Kerala High Court. Facts of the case. The Centre for Professional and Advanced Studies, CPS, is a society registered under the Travancore Cochin Literary Scientific and Charitable Societies Registration Act. It was formed to take over the self-financing institutions under Mahatma Gandhi University. The petitioner was appointed as a lecturer on a contract basis under Centre for Professional and Advanced Studies in 2012 for 3 years. In 2014, she was granted maternity leave for 180 days and the entire leave period was sanctioned with allowance. Her appointment was later renewed for a further 3 years with effect from March 2015. During the course of the employment, the petitioner conceived once again and she applied for maternity leave for 180 days. As per the special rules framed by Centre for Professional and Advanced Studies which were approved by the state, the maternity leave is provided for 180 days, maternity leave benefit has been limited to 90 days. Therefore, Centre for Professional and Advanced Studies sanctioned maternity leave for 180 days but limited leave with allowance to 90 days. The petitioner moved the single judge arguing that denial of maternity leave with allowance for 180 days was in violation of the Maternity Benefit Act and the instructions contained in the circulars issued by the Ministry of Women and Child Health. She pointed out that the rules framed by Centre for Professional and Advanced Studies were only approved by the state in 2018 and therefore, her service conditions cannot be altered to her disadvantage during the course of her employment. The single judge allowed the petition and held that the petitioner was entitled to maternity leave with allowance for 180 days notwithstanding the taking over of the self-financing institutions of the Mahatma Gandhi University by the Centre for Professional and Advanced Studies. Challenging this order, the Centre for Professional and Advanced Studies approached the division bench with an appeal. Decision. The Kerala High Court ruled that female officers appointed on a contract basis are entitled to the benefit of the Maternity Benefit Act. The court further ruled that the term establishment under the Act can be any establishment within the meaning of any law that is in force in the state in relation to establishments. Upon examining the relevant provisions and precedents, the division bench of Justice P.B. Suresh Kumar and Justice C.S. Sudha also concluded that the special rules of a registered society cannot override the provisions of the Act, which is a central act. The bench also noted that as per a government order issued in 2021, the state has extended the benefit of maternity leave on full pay as per the Kerala service rules up to 180 days or till the expiry of the existing contract, whichever is earlier, to female officers appointed on contract basis, irrespective of the tenure of the contract. Moreover, Section 5(2) of the Maternity Benefit Act says that no woman shall be entitled to maternity benefit unless she has worked in the establishment for not less than 80 days in the 12 months immediately preceding the date of her expected delivery. The court found that the appellant did not have a case that she had not worked for 80 days as contemplated thereunder. The court also observed that the Act is admittedly a beneficial piece of legislation with an object to see that a woman employed at the time of advanced pregnancy is not compelled to work as it would be detrimental to her health and also to the health of the fetus. It is for this reason that the Act provides for maternity leave for certain periods prior to and after delivery. As such, the appeal was dismissed and the decision of the single judge was upheld. Case details. Thank you. Email ID legalbuddy@gmail.com